Welcome to Legal and Financial Basics. This program today, very pleased to be, I am very pleased to tell you that it will be presented by our longtime friend and supporter here at Alzheimer's San Diego, volunteers a great deal of time and expertise to our education program and generally supports us at Alzheimer's San Diego in our mission to support our local community. Attorney Andrea Gherini with the law office of Andrea M. Gherini. I am going to actually be moderating the program here today, but my colleague Jean Alton is also with us. Many of you know Jean from our education program. I would like to welcome Andrea Gherini to take over. I'm going to be behind the scenes here, Jean and I, and we will look forward to your presentation.
Thank you. Thank you, Amy. Thank you, Jean. It's a pleasure to speak in front of all of you for another opportunity to share this information. I wish I was present face-to-face, but this is the new normal and we're getting used to it. So the first topic is advanced care planning basics. And advanced care planning is really making decisions about the care you would want to receive if you're unable to speak for yourself. So it ensures that future decisions are made according to your personal values and your preference. In order to do advanced care planning, it requires you to discuss your personal values, your legal and financial planning with lawyers and doctors, and to communicate your wishes with the people you're choosing to make decisions for you. You can go next slide. So here Dr. Lynn says advanced care planning is about planning for the what ifs that may occur across an entire lifespan. Another way of thinking about it is it's planning about you and what's important to you, and then it's about what happens to your stuff. Go to the next slide. So the value of planning ahead is extremely important. It can't be dismissed. We all need to establish a plan for healthcare decisions and asset management decisions when we are too ill to make these decisions ourselves. By planning ahead in the need of assistance, you can identify and communicate your wishes. You can establish a legal framework to ensure your wishes are honored. You can avoid decisions being made in a crisis. And you can preserve eligibility for public benefits, avoid probate and court proceedings. And by planning ahead, you can maintain being the captain of your team, create a support team with expertise in estate planning, public benefits, healthcare, and incapacity planning. So I think we're going to look at some definitions, key concepts. So before we discuss the various types of planning, we need to know the terms that are used in this area of the law. And estate planning is really the administration, protection, management, and distribution of assets in a manner that's consistent with the goals of the owner. The establishment of a plan for making financial decisions and healthcare decisions during your life, as well as the distribution of your assets on your passing. In order to establish a plan, you need to discuss your values and your assets with your attorney. You need to review the beneficiary designations on your retirement accounts and your life insurance policies. The planning typically includes the creation of various documents that carry out your wishes. So for example, a trust, a power of attorney for financial management, an advanced healthcare directive, or often called a power of attorney for healthcare, and a will. Additionally, the Health Information and Portability Accountability Act, otherwise known as HIPAA, mandates that healthcare providers maintain your confidentiality. So it's important that you sign waivers of that HIPAA protection so the medical profession can talk to your family members and they can participate in healthcare decisions. So next we're going to look at benefits planning. And that's really focusing on the determination of eligibility for public benefits, including planning to prevent spending down all your assets to obtain eligibility. Benefits planning also encompasses reducing share of costs once public benefits are received and avoiding a recovery claim against the estate of a person receiving public benefits. The next term, special needs planning, is focused on protective planning for individuals who have a developmental disability, who are currently receiving needs-based government benefits such as SSI or Medi-Cal. And so it's planning to protect those benefits should they inherit assets or receive assets in an accident claim. Capacity is the next term. And capacity means the capability or fitness to perform an action, enter into a legal agreement, the ability to understand the nature and consequences of one's actions. Capacity is not fixed. A diagnosis of dementia does not necessarily equal incapacity. In the law, there are different levels of capacity that are recognized. To make a will or a simple trust, one must generally know what he owns, who he wants to receive his assets on his passing, and to choose a person to make decisions to carry out those wishes. One of the lowest levels of capacity is to marry. So be careful. The next slide is conservatorships. Conservatorship is a court proceeding where an individual is appointed by the court to care for an adult's personal needs or financial assets. The person appointed is under court supervision, and the individual in need of care loses constitutional rights to make decisions. A conservatorship is commonly used when the person's incapacity is permanent. Additionally, a conservatorship is needed when an incapacitated adult fails to plan when he or she has capacity. So he doesn't have a durable power of attorney, or she doesn't have a healthcare directive. And the only way a person can become legally empowered to make healthcare decisions is through a conservatorship. The other time that conservatorships become necessary is when people have done the planning, but the planning is not working in the situation. Either the documents don't cover the situation that's presented, or the documents don't protect people from making unwise decisions, such as gambling their money away. In those situations, a conservatorship may be necessary. Now we're moving on to essential documents, or key legal documents, as the agenda says. And this slide basically identifies four: a will. And a will can be either a traditional will that transfers all your assets on your death to people you identify, or it can be a pour-over will, which transfer assets to a trust. A will only operates when you die. It takes a court proceeding to appoint an executor to distribute your assets according to a will. So a pour-over will confirms that everything passes to the trust. If assets are not titled in the trust, then the will pours the assets into the trust. So the trust terms apply to the distribution on death. But if too many assets are left out of the trust, it will require a probate of the pour-over will to transfer the assets of the trust. And typically in California, we're trying to avoid probate because of the costs incurred and the time it takes to probate a will through the courts. So in order to avoid probate, People use trusts. Attorneys recommend a living trust, which will provide asset management during your life, when you become incapacitated, and after your death. And in a trust, there are various roles. And the first role is the trustee. The trustee is the owner of the property and the manager of the property. The beneficiary is the person who receives trust income and assets. And then there's the trustor or the settlor or the grantor. Those terms all mean the same thing: trustor, settler, grantor. And they refer to the person who creates the trust and transfers property to the trust. So when you're healthy and you create a trust, you are the trustor, trustee, and beneficiary. If you become incapacitated, your successor trustee manages trust assets for your benefit. You're still the trustor, you're still the person who created it, and you're still the beneficiary, so long as you're living. It's very important to choose a successor trustee who is trustworthy, who knows your values, who knows the difference between your money and their money. The person you choose as the successor trustee should also be the person who operates as your financial agent under the durable power of attorney. So financial decisions are made in a coordinated fashion. The trust terms must allow a trustee to amend the trust to do Medi-Cal planning. And I'm saying must. Many trusts don't allow a trustee to amend a trust to do medical planning. So this is my recommendation to you, that if you have a trust, you must have a provision to allow the trust to be amended to do Medi-Cal planning. The trust should also include terms that permit a trustee to make gifts in order to qualify for eligibility for Medi-Cal. Finally, the trust needs to be funded. A trust is a relationship. It is not an entity when you sign it, and it only operates, the terms of the document only operate on assets that are put in the trust. So when I meet with people face to face, I use this box as a visual aid to show what a trust is, and it's empty when you sign it. So it's very important that you put your house in the trust. You have another rental property goes in the trust, your bank account, your brokerage accounts. This is how you fund a trust, so it's not an empty box. So the next basic document is the durable power of attorney for financial management. The power of attorney is a writing that gives authority to someone you trust to make financial decisions for you. The person acting for you is called your agent, and you are called the principal. The durable power of attorney remains in effect during your incapacity. So powers of attorney can come in various flavors. There are immediate powers of attorney, springing powers of attorney. For example, an immediate power of attorney authorizes the agent to act on the principal's behalf whenever appropriate, whether the principal has capacity or is incapacitated. The principal does not give up his or her authority to act by signing a power of attorney. As long as the principal has capacity, either the principal or the agent may act on the principal's behalf. Now, contrast that with a springing power of attorney. This durable power of attorney springs into effect upon the happening of some event specified in the document itself. The most common triggering event for a springing power of attorney is the principal's incapacity. So whatever the triggering event is, a springing power of attorney should specify who determines that the triggering event has occurred and how the determination is made. So one example could be the determination is made by a physician or two physicians. That determine the person lacks capacity. So the triggering event is a written statement from the physicians that in the physician's opinion, the person lacks capacity. A power of attorney can also be drafted so that it's a hybrid. It's effective immediately as to your spouse or your initial agent, and it's effective on your incapacity as to all successor agents. The durable power of attorney gives the agent general and specific powers to deal with your real and personal property that is not in your trust, such as retirement accounts or life insurance contracts. It's recommended while you have capacity to give a copy of your durable power of attorney to financial institutions that hold these assets that are not titled in your trust. In this way, you can find out if there's any additional paperwork that they require before they will accept the authority, your agent's authority under the durable power of attorney. A durable power of attorney terminates automatically on your death. So it's different from a trust. It only authorizes someone to help you during your life. In order to do Medi-Cal planning, your durable power of attorney must have specific language, granting the agent the authority to amend a trust or create an irrevocable trust if the principal lacks capacity. There should also be specific language allowing the agent to make gifts in excess of the annual exclusion amount of $15,000 per year. It's also recommended that there be specific self-dealing language. This means that an agent can make decisions even if the agent benefits from the decisions. So a durable power of attorney should also provide your agent with access to online bank accounts and possibly the authority to encumber real property with a reverse mortgage. So you can see from all these examples, a power of attorney can be a license to steal in the wrong hands. Therefore, the most important decision you make is who your agent will be. When creating these basic estate planning documents, there's a tension between maintaining confidentiality of your financial affairs and transparency, permitting people you trust to know about your finances. It's recommended that you give an attorney permission to speak to your agent. Otherwise, the attorney cannot speak to the agent, even if you become incapacitated. Guidelines can also be provided within the durable power of attorney to provide checks and balances, such as mandating that the agent provide an accounting to your other children or to your CPA or your attorney, someone you trust. It's important to note that while all estate plans include a power of attorney, not all powers of attorney are written in the same way. And often only an elder law attorney will include all of these broad provisions in the document. So it's important that you have a conversation with your attorney and let them know the powers you want your agent to have. Then the last basic document is the healthcare directive. And the healthcare directive works a little bit like the power of attorney, but for healthcare. It is a writing that gives authority to someone you trust to make healthcare decisions. In California, the healthcare directive has 4 parts. It appoints an agent. It sets forth your instructions for end of life. It sets forth your wishes, whether you want to donate organs at your death or not. And it allows a place for you to name a primary physician, but you don't need to. Just as within a power of attorney for finances, the most important decision you're going to make under the healthcare directive is likely who is your agent going to be? Your agent should be someone who knows your wishes, that has the personality to be an effective advocate for you with healthcare providers. Your agent should be a diplomatic listener. For example, the agent should have the capability to talk to the doctor, the nurses, and say something like, help me understand how the treatment you are suggesting will help me honor my mother's wishes. Be sure and choose alternate agents in case your initial agent is unavailable. The healthcare directive gives the agent the authority to make placement decisions. If you do not want to be treated in a facility and you only want to be treated at home, this is the document in which you should set forth these wishes. You're also going to set forth your wishes regarding instituting or withdrawing artificial nutrition and hydration, pain control, use of antibiotics. If you want to participate in research studies, your agent must be given this authority and specifically. If you want the agent to limit your driving privileges, which most people don't, but if you did, you must specifically include this power in the healthcare directive. Otherwise, the agent cannot limit your ability to drive. You can consent or refuse to consent to treatment, services, or procedures. These provisions can include the level of care you want if you have dementia or Alzheimer's disease. The agent will receive, review, and can request medical records. They can execute medical releases and waivers, authorize an autopsy, make anatomical gifts, and direct the disposition of human remains. But those authorities must all be set forth in the document. If any of that is missing, then they don't have that authority. The authority granted in the Advanced Healthcare Directive is wide-ranging. So it's really important that you communicate your wishes to your agent. And there's some resources that I'll point out at the end of the talk that help you have those conversations. There's also provisions for the type of care you may want if you have dementia, and I'll point those resources out at the end. Finally, there is the HIPAA waiver that I referred to earlier, which allows healthcare professionals to speak to family and friends that you identify that you want to be privileged to help your healthcare decisions. Now, separate from an advanced healthcare directive is a do not resuscitate order and a physician's order for life-sustaining treatment. These are not documents that lawyers prepare. These are medical orders that your physician signs after discussion with you, and it directs the level of treatment that medical personnel shall administer to the patient. So the PULSE and the DNR are medical orders. The Advanced Healthcare Directive is not. It's the appointment of an agent to make healthcare decisions. Emergency medical technicians are not required to honor an Advanced Healthcare Directive, but they are required to honor a PULSE or a DNR. I think we're ready to move to the next slide. So maintaining current documents. Nothing in life stays the same, and neither does the law. Your plan should be reviewed whenever there are significant changes in your family: births, marriages, divorces, medical diagnosis. Your son marries that woman. The persons you nominated as trustees, financial, or healthcare agents may no longer be able to fulfill the role. So you need to check on updating those appointments in your documents. If you've refinanced your house or purchased a new property out of state or opened a bank account, A new branch offering a higher interest rate. Are these new assets titled in your trust? It's important to periodically review your assets, your beneficiary designations, to make sure they're up to date. Has everyone shared their online passwords or where their passwords are kept? You should record the passwords and the security questions so your agent can have access to your financial records. We're beyond the days where we get our checking account statements in the mail or our financial statements. Last but not least, the law changes constantly. AB trusts are no longer necessary to reduce estate tax. The Medi-Cal recovery rules changed in 2017, making it easier to pass property to your spouse and beneficiaries without a recovery claim by the state of California. In 2018, the rules regarding children being able to stretch out the distribution from an inherited IRA changed. And just last year, California voters dramatically limited the ability of children to inherit real property from their parents without a reassessment of property taxes. So, because things constantly change, people, laws, relationships, it's important to review your documents. I think we're ready for questions, maybe?
Yes, Andrea, we've got quite a few questions actually.
Okay.
And I just want to let everyone know, we'll do our best to try and get to all of these, but I'm not sure we'll be able to because there's lots coming in. So I'm going to kind of condense a couple. The first questions have to do with capacity, Andrea. And in this vein, we've got a person asking, what if the person you are caring for no longer has the ability to communicate clearly with regards to, verbally and or writing, stating who they would like to be their power of attorney. So they may not necessarily have an issue with capacity, but they're having a problem with communication.
And if they can't verbally communicate and they can't write, capacity could be determined by if they could point out and recognize people in the pictures they want. That is an alternative, so that they can, if they can recognize family members and tell a lawyer that this is in answer to the question of who they want, a picture of a group of people, they can point to the person they want. We've done things like that before, but also there are capacity tests that doctors can give that help lawyers determine whether a person has capacity, and in something like that may be needed.
All right, and we've got another one here. The power of attorney form has been filled out, but the family has not been able to get it acknowledged by a notary as yet. So what is the time frame that says that now it's too late, it needs to be started over or redone?
Well, a notary can acknowledge the signature of a person that signed a document on an earlier date, as long as that person has a valid ID. So if that person signed it and he has a valid ID, the notary will come and acknowledge that it was signed, not today, but signed a year ago. Because all the notary is doing is acknowledging the signature.
Got it. Two more questions with regards to power of attorney and capacity. First of all, does a person living in San Diego need to have a power of attorney that is local, or could it be somebody that lives out of state?
Oh, an agent under a power of attorney? It doesn't need to be local.
Okay.
More importantly, it needs to be provided to the financial institutions to make sure that they will accept it.
Okay. And lastly, we have here a family that has a mother that has more advanced dementia. And there's no power of attorney, no trust, none of those things have been put in place. What does this family do?
So that sounds like the example of a conservatorship.
Okay.
So in order to make financial decisions for this mother, a conservatorship may need to be imposed so that somebody can access her money, pay her bills.
One last question here. That's a good one. If a family doesn't, or a person doesn't have any family members or close friends available or willing to take on the role of power of attorney, what would be the options?
So we're lucky in San Diego that we have a very robust population of people called financial fiduciaries, professional fiduciaries. They're licensed, they're bonded, and they serve in these capacities for a fee. And so if there is a reasonable amount of assets that can afford to hire somebody, there are people that are very good to serve in these roles.
Great. And oh my gosh, there's just lots of questions, and we're just, unfortunately, folks, we're not going to be able to get to them
I don't mind
all.
staying a little bit after this is over to answer questions.
Yeah,
If
we'll
that would be
let you
helpful.
keep going, Andrea, and we'll try and pick out the ones that everybody might have questions about.
Sure.
Thank you.
I'm going to, okay, so we are going to focus on strategies for financing long-term care. And let me get myself oriented, and there's my notes. So what is long-term care? So long-term care is custodial care. It's the settings that it's offered can be very different, but it's care that provides non-medical services and supports, and it's assistance with activities of daily living for people with physical or cognitive disabilities. So what are activities of daily living? Think of the acronym BATTED. It's bathing, ambulating, toileting, transferring, eating, but not meal preparation, and dressing. So the cost of custodial care on the next slide really depends on the venue that it's being provided. So there is care in the community, which includes home care, adult daycare programs. There is a program called PACE, which provides a variety of medical and support services so seniors can remain in their home. And the costs of those care really, depend on whether it's full-time or part-time or occasional time. But full-time in-home care is the most expensive care that you can obtain. Then the next level of care is residential care facility. These are state licensed facilities to provide non-medical care or custodial care. And they include board and care homes, assisted living facilities, facilities that are identified as memory care facilities, or continuing care facilities, continuing care communities, such as you buy into it and it provides all different levels of care throughout the span of your life, from independent to assisted to skilled care. Then the next facility, the level of care, are skilled nursing facilities. These are also state licensed, and they provide custodial as well as medical care. So how do we pay for all this care? The next slide shows the combination, and it's usually somewhat of a combination. There's personal savings and assets. Some people have long-term care insurance. There's financial tools where you can convert assets to making a bucket for paying for long-term care, such as a reverse mortgage or a charitable annuity. There are some life insurance products that are hybrid. If you don't need it, there is a life insurance benefit to your heirs. If you do need it, it pays out a portion of life insurance to, it pays out a portion of long-term care insurance to pay for your care. There are veterans benefits. There is also Medi-Cal, long-term care in skilled nursing home, government benefits through Medi-Cal to pay for skilled nursing care. And then there are a number of Medi-Cal waiver programs, which are available to people who meet the criteria, that meet the criteria for long-term care in a skilled nursing facility, but are able to get that care in the community or in a residential facility. Medicare does not pay for long-term care, and that's usually a surprise to people. So the next slide, if you're private paying for your long-term care, these expenses may be deductible or partially deductible. And so you need to discuss with your tax professional whether you can deduct some of these expenses. And it's important to identify these expenses to the person who does your tax return, because they seem to be unaware of it sometimes. So if a person requires custodial or skilled care and you're paying for home care, those expenses are deductible. Residential care services, custodial or skilled, are deductible. Medical expenses that insurance doesn't cover may be deductible, such as transportation. Personal care items, medical equipment, durable medical equipment, home modifications, and of course, long-term care insurance premiums. And so whether these expenditures are deductible depend on the following. The expenses must exceed 7.5% of a taxpayer's adjusted gross income. The services must be prescribed by a healthcare practitioner. The services must not be covered by insurance. The services that are provided are either diagnostic, preventative, for treatment, rehabilitation, or personal care, which opens up a variety of services that you're paying for. Services are required by someone who is chronically ill. And the definition of chronically ill is being unable to perform at least 2 activities of daily living without substantial assistance, or be suffering from severe cognitive impairment. So again, that acronym comes up: BADD, bathing, ambulation, toileting, transferring, eating, and dressing. If a person needs assistance with at least 2 of those activities, the services that they are paying for may be deductible. So now we're going to focus briefly on employment considerations, which is the next slide. So if you are, or you know someone, or are caring for someone that may have young onset dementia, that they're still in the workplace, this disability is covered by the American with Disabilities Act. And it's important to know that so that you can take advantage of whatever benefits the person's company may have available. So often there is a need for planning, if the person is still in the workplace and wishes to stay in the workplace. So highly recommend that someone help them review the disability, sick leave, and insurance options. The ADA, the American with Disabilities Act, covers employers with 15 or more employees. And if your employment is covered by the ADA, you can request accommodations, and an employer has an obligation to conduct an interview with the employee to discuss any reasonable accommodations that the employer may be able to make so that the employee can keep their position. There's also government programs, both state and federal, that offer resources to guide employees through difficult times. There's state disability benefits, SDI, which provide benefits for up to 12 months of disability. The Family Leave Act provides up to 4 months of leave and 6 weeks of paid disability. And there may be early retirement options or long-term care disability insurance. I think one of the things to stress in this area, if you know someone that potentially could be experiencing symptoms of young onset dementia, it's so important to get a diagnosis, because oftentimes their behavior causes them to be fired before they have a diagnosis. And if they're still in employment, they can take advantage of the benefits that the employer may have, such as disability insurance or long-term care insurance. Then the next slide talks about compassionate allowances. And the compassionate allowance is a program under federal law that expedites the processing of Social Security disability insurance and supplemental security income claims. So if you have a diagnosis of various types of dementia, you don't have to prove that you have a disability. You're per se found to be disabled, and therefore your claim for disability insurance is fast-tracked. And the next slide lists the different types of dementia diagnosis that is included on the compassionate allowance list. And it was interesting looking at this list, because a year ago, there were about half as many types of dementia on the list. So it sounds like the federal government is getting more educated as to the various types of dementia that can occur, and fast tracking the disability benefits. So then we're going to transition to VA benefits. And I apologize in advance if there's not many veterans in the audience or people who are caring for veterans, because there are a number of VA programs that I'm going to focus on just because I don't know who's in the audience. And one of the easiest programs to make yourself available is the health insurance program. If you served any active duty and separated from the military under a condition other than dishonorable, you have the ability to get health insurance through the VA. And Vietnam veterans are afforded priority status when applying. And the importance of being available to get health insurance from the VA opens up a number of other programs that are available to you. You don't have to change doctors. You just have to have your VA health insurance number. And so one of the other programs that's available is called the Jerry Pact. These are care teams that provide healthcare for veterans with more than one chronic disease and with declining mental and physical capabilities. Jerry Pact integrates traditional healthcare services with community-based services. and it includes healthcare teams who possess expertise and advanced training to assess and address the illnesses and the issues of elderly veterans. The goal is to optimize independence and quality of life. And depending on the veteran's needs, services may include a home-based primary care, home health aid for a few hours a week, respite for a few hours a week so the well spouse can get out and do the grocery shopping, adult daycare, outpatient clinic, and caregiver support is an essential part of these services. Then there's service-connected disability income. Service-connected disability is a disability related to the veteran's active military service. And a veteran can be rated anywhere from 0 to 100%. Service-connected disability compensation is tax-free income, and the amount of the compensation is based on your rating. There's also pension benefits. Traditional pension benefits require the veteran to have served a minimum 20 years in service, and the amount of the compensation is based on the rank and year of services. And there's also a non-service connected pension called aid and attendance. And this is a benefit for veterans or surviving spouses. And it's not connected with their length of time in service, but it is available to veterans who served during wartime and whose unreimbursed medical expenses exceed their income. So the veteran or the surviving spouse must be homebound and need assistance with at least 2 activities of daily living. Remember, batted, bathing, ambulation, toileting, transferring, eating, and dressing. So at least 2 of those activities. Unreimbursed medical expenses must exceed income in order to receive the maximum benefit. Now that for this benefit, the VA includes assisted living expenses as a medical expense. So if a veteran is living in an assisted living facility and is paying $7,000, $8,000 a month for the facility, which includes care as well as room and board, the entire amount is considered a medical expense for VA purposes. In 2021, this year, a veteran could receive up to $1,936 a month in pension benefits, and a veteran with a spouse could receive $2,295 a month, and a surviving spouse of a veteran could receive $1,244 a month. However, this program is needs-based. You can have a house, you can have $130,000 of assets, and then your income can be any amount as long as you're paying all of it out on medical expenses. You can't give money away to qualify for this program or property away without incurring a penalty. And so the VA will look at transfers that a veteran makes in the 36-month period prior to them applying for this benefit. The VA Caregiver Support Program, I think, is the next slide. Yes. This is another benefit for any veteran who enrolls in the healthcare program and meets the clinical need for service, and that the program is available in their location. But look at the list of programs that are available: adult daycare or half-day programs 2 or 3 times a week, possible up to 5 days a week, home-based primary care program, homemaker and home health aid program, respite care, temporary placements so a caregiver can get a break, skilled home care service, and home hospice care. These are all programs that are managed by the VA. Some are at no cost, some are at reduced costs, but they're really worthwhile if you have a veteran that you are caring for. So the next slide, we're transitioning to Medicare. And Medicare is a federal health insurance program. It's paid for out of Social Security deductions. It's an entitlement program. It's not based on financial need. All of us who turn 65 and have made contributions during our work history are eligible for Medicare. People under 65 who have received Social Security disability for at least 2 years can also receive Medicare health insurance coverage. So Medicare has 4 parts. Medicare Part A is hospital insurance, and that's free. None of us pay for it who are on Medicare. Part B is outpatient medical services, such as doctor visits. You must sign up for Part B when you turn 65, or there's a penalty if you sign up late. And it pays 80% of the outpatient or doctor visits bills. And then people purchase a private supplement to pay the other 20%. Part D is prescription drug coverage, which you also sign up for when you turn 65. And Part C replaces B and D in a sense. It's Medicare that are managed care plans. And so the government has approved various private insurance plans which cover outpatient and prescription coverage. And you can choose to forego your traditional Medicare benefits under B and D and instead sign up for Part C, which is typically less out of pocket for the individual, but may have some limitations on the benefits under the plan. So Medicare benefits for skilled nursing. I said that Medicare benefits aren't available for long-term care, but they are available for rehabilitative care in a skilled nursing facility. So when you are hospitalized for some injury or ailment, Medicare will cover a stay in a nursing home after the patient has been hospitalized for 3 days, 3 24-hour days. And the maximum Medicare skilled nursing coverage is 100 days per ailment. And there's typically a co-payment from day 21 to day 100. Very often around day 20, a facility is looking to discharge the patient, because at day 20, the facility must show that the patient requires skilled care to maintain their condition. Otherwise, Medicare will not cover the stay. The patient need not show that they are improving, though, only that their condition would decline if skilled care, such as physical therapy, occupational therapy, speech therapy, was not continued to be offered to them on a 5-day-a-week requirement. Medicare does not cover custodial care. So now we're going to look at Medicaid, which in California is called Medi-Cal. And Medi-Cal is a state and federal program that provides low-cost health care coverage for children and adults with limited income. Medi-Cal also provides long-term care coverage in a skilled nursing facility and in some community-based settings. California's Medi-Cal or Medicaid program is unique because it provides protections for the middle class. It does not require a spend down of assets, and it provides protections for the well spouse. Medi-Cal is generally not the goal for most couples, but at the same time, there are regulations in place which allow couples to avoid becoming impoverished if a spouse is placed in a skilled nursing facility. So, eligibility for Medi-Cal begins on the next slide. So, persons who are receiving SSI, supplemental security income, are automatically eligible for Medi-Cal. And then individuals whose income make them ineligible because it's too high may also be eligible if they qualify under Medi-Cal's medical needy provisions, in which case they would be eligible for Medi-Cal, but they would have a share of cost. They would pay a portion before Medi-Cal would kick in. Threshold issues in determining eligibility. The care must be medically necessary, which means a physician must order the care in a skilled nursing facility or be of the opinion that the patient needs the level of care that is offered in a skilled nursing facility, even if the care is being provided someplace else. If the facility must be Medi-Cal certified, if we're talking about skilled nursing facilities, a resident must be likely to remain or does remain in the skilled nursing facility 30 days or more. So I said that California is very generous in providing ways to become eligible, but because they're so generous, it's often difficult to find a bed in a Medi-Cal facility. There are placement issues because Medi-Cal pays the facility less than a private pay patient. So facilities will often say, we don't have any available Medi-Cal beds, or we only have 2 Medi-Cal beds, and they're only available for our community residents. Well, in reality, every bed in a Medi-Cal certified facility is potentially a Medi-Cal bed. So it's just wrong information that these social workers give out. If you are contemplating the need for skilled nursing facility care, the best time to get a bed in a Medi-Cal licensed facility is after a stay in the hospital, a 3-day stay in the hospital, in which you are transferred to a facility and Medicare is paying for it, because all the facilities love to have Medicare patients because the reimbursement rate is much higher. And then you transition to Medi-Cal if you continue to need custodial care. You have to make the decision, though, upon leaving the hospital, that the facility that you're going to be transferred to for rehab is Medi-Cal licensed, because they're not all licensed in San Diego County for Medi-Cal. Many are just licensed for Medicare. So some of the key concepts that have to do with Medi-Cal eligibility that we talk about in this area is share of cost, the amount of money a Medi-Cal beneficiary must pay towards their medical services before Medi-Cal will begin to pay. Spending down. As I said, Medi-Cal is a program that is available to persons with limited assets. Applicants can spend down their assets on care to become eligible for Medi-Cal. However, in California, there are many other alternatives to spending down assets. Estate recovery. Many people tend to be worried that if we go on Medi-Cal or a family member goes on Medi-Cal, the estate will come and collect the assets from the family members after the person passes. And while this may be true in other states, in California, the laws have changed and they're very limited in the situations in which the state of California will file a recovery claim. The assets that pass through probate via a will are the only assets that are subject to recovery in California. So as long as assets pass through a living trust or a beneficiary designation on an account, there is no recovery by the state for Medi-Cal benefits. Okay, so the thing to look at on the next slide, oh, you're already there, is that there are various types of Medi-Cal programs. And we focus a lot on the skilled nursing facility program, but there are other types of programs that are geared to keeping people at home. And part of the problem is that they are impacted by lack of assisted living facilities or lack of potential home care workers. And so it's oftentimes difficult to get people to serve you under these programs, but they do exist and you should know about them. And the first one is in-home supportive services. An individual may qualify for Medi-Cal benefits at home. The county will do a needs assessment and that person can potentially have up to 280 hours of home care per month. The county of San Diego will pay a family member or a third-party caregiver approximately $15 an hour to provide care. But there are income and asset requirements depending on whether the Medi-Cal applicant is married or single. If married, the wealth spouse can keep more assets and income. If single, the individual's assets must be at $2,000 or less, and the income must be under about $1,400 a month. Then there are community-based adult services. PACE is an example. There's a PACE program, St. Paul's in San Diego. There's one that's opened in San Marcos. And I understand there's one under construction in Encinitas. And these are managed care plans, which include daycare to enable individuals to live safely in the community with some assistance. And these are available for people on Medi-Cal at no cost or Medicare with a share of cost. And then there's the assisted living waiver program, where Medi-Cal will pay for care in a residential care facility as opposed to a skilled care facility. And the individual pays for room and board at a rate of about approximately $1,200 a month, but their income cannot exceed $1,500 a month. They must be able to qualify for Medi-Cal without a share of cost. They must require assistance with at least 3 activities of daily living, and there are long waiting lists to get a bed in an assisted living waiver facility. So you can become eligible for Medi-Cal and then be on a waiting list for 18 months or 2 years for a bed to open up. So let's dig deeper into the eligibility requirements. Medi-Cal looks at property and assets and puts them in 2 different categories, exempt and non-exempt. So all assets having the name of the Medi-Cal applicant or a spouse or a co-owner must be disclosed on the Medi-Cal application as of the first day of the month in which the application is filed. Some assets are counted or non-exempt, and other assets are not counted, considered exempt. So the exempt assets include the assets on this screen: a house. Retirement assets and pensions that are paid to the ill spouse are not counted as an asset. Retirement assets of a well spouse are not counted. A spouse in the nursing home can have $2,000 in assets. They can have one car, they can have life insurance with a cash value of $1,500 or less, and then they can have term life insurance of any value. And then there are various spousal protections that are shown on the next slide. So the spousal protections are the first one is known as the Community Spouse Resource Allowance. So in addition to the assets that I listed above, the house, retirement assets, a car, life insurance, up to $1,500, if it's a married couple, the community spouse can retain a certain amount of liquid assets that don't include the exempt assets, and that amount is currently $130,380. This amount generally increases each year. And so in addition to the Community Spouse Resource Allowance, or sometimes called the CSRA, there is something called the Minimum Monthly Maintenance Needs Allowance. And this is an income benefit to the community spouse. The community spouse is entitled to keep a certain amount of income while the disabled spouse is in the nursing home. So the whole idea is not, under the federal law, is not to impoverish the well spouse. So she is entitled, or he is entitled, to keep $3,260 per month of income. And if she has more income in her own name, she's entitled to keep that. And she may be entitled to keep part of the ill spouse's income if her own income is less than $3,260 per month. So the idea is the minimum monthly maintenance needs allowance is a minimum income allowance. She can have more, or he can have more, the well spouse can, but they can't have less than that amount without there being an allocation from the ill spouse's income. So then the balance of the income of the ill spouse, or the person in the nursing home, is paid to the nursing home as a share of cost. The ill spouse is only entitled to keep $35 a month, and the rest of that person's income is paid to the nursing home as a share of costs, and Medi-Cal picks up the difference. Any unpaid medical expenses that the person has when they enter the nursing home can reduce the share of costs for the first couple of months. So I know this is a lot of very technical information, and so I understand if you have questions and you feel lost, and I apologize for that, but that's the way this program works. So now we're going to talk about, you have a basics of understanding of the income tax, the income rules, the asset rules, the spousal protections. And now we're going to talk about the various alternatives for planning to become eligible for Medi-Cal without incurring any penalties. So To give you an overview, generally in other states, if a person gives money away, there is a penalty imposed, and a penalty can last up to 60 months, depending on the value of the property or money given away. So California is different because our look back period is 30 months instead of 60 months. Additionally, we can give assets away to become eligible for Medi-Cal without incurring any penalties. It won't always be this way in California. They have passed laws to change this to make us in compliance with the rest of the country, but the laws haven't taken effect. They haven't been implemented. And they haven't been implemented for about the last 5 years. They were passed around, I think 2015, maybe. In any event, I don't know when they're going to be implemented, but they have said that there will be no retroactive effectiveness. So all of us continue to operate as if they are under current law, which allows gifting without incurring a penalty. So whenever you do gifting, you have to be aware that Medi-Cal can request copies of financial records back 30 months. And if you transfer money or assets to one person on one day that exceeds $10,000, $10,298 on one day, that transfer incurs a 1-month penalty, meaning that you're ineligible for Medi-Cal for 1 month because you gave away $10,298. However, not all transfers are subject to this rule. You can give the house away without penalty. You can make transfers to your spouse or disabled children without penalty. And you can transfer less than $10,298. So you can transfer $10,297 per day, per person, and it does not result in a penalty. So before you go out and decide to give away all your assets to become eligible for Medi-Cal, there are income tax ramifications in making transfers. They can be property tax ramifications in making transfers. So you need to discuss your concerns and your plans with an elder law attorney before making a gift of assets. Spend down is an appropriate strategy if a person is single or even a couple, if it will preserve quality of life or enhance quality of life. Use the money to pay for respite help, adult daycare to avoid caregiver burnout, pay down a mortgage, make deferred maintenance, repairs, renovations on a house, prepay property taxes, insurance, homeowners fees, pay for dental work, glasses, or hearing aids. Those are all appropriate spend downs that enhance a person's quality of life. For a married couple, a spend down can be avoided because there is a court proceeding that is called a 3100 petition, and it allocates assets and income to the well spouse. So a married couple is really not required to spend down their assets for the ill spouse to be eligible for Medi-Cal. This petition is very widely accepted in San Diego County, and the judges are favorably inclined to move income and assets to the well spouse in order to ensure that the well spouse does not become impoverished by the ill spouse's disease and need for skilled care. It's not an inexpensive procedure, but it is a very valuable alternative to preserve assets rather than giving them away. Then there's also rules about recovery that have changed in California. And I think I've mentioned this earlier, but California, the state of California, will only recover against assets that are subject to probate. So there's no recovery against assets held in a revocable trust. There's also no recovery against surviving spouses. So this is another reason to do advanced planning, avoid probate and avoid a recovery claim if you or your spouse ever receive Medi-Cal benefits. And then finally, how do you apply for Medi-Cal? You can apply online, in person, or via mail. The important thing is, though, you don't apply until you meet the eligibility requirements. So if you're doing gifting or you're retitling assets, you make sure that all that's complete before you apply for Medi-Cal. Then it gets disclosed in the Medi-Cal application, but as long as it's done in conjunction with the advice of an elder law attorney that is guiding you through this, there is no penalty if the gifting was done correctly, or you wait until the court order has been obtained allowing for the spousal protections under the 3100 petition. Lastly, once you're on Medi-Cal, there is a review done every 12 months to determine if an individual still qualifies as medically needy. And you can lose benefits if assets come in the hands of the individual receiving Medi-Cal. For example, the IRA is not counted as an asset, but if it is cashed in and turned into cash, it becomes an asset. The house is not counted, but if the house is sold, the cash becomes a counted asset and exceeds the $2,000 limit, and the individual will lose benefits. So I think we're up to questions.
We are, and I just want to say we're getting pretty tight on time here. So
Okay.
Jean, I'll ask you to tighten it up as best you can.
Yeah, I'm just going to go straight to, this is going to be kind of a summary question on Medi-Cal. And what people are asking in a few different questions is the whole spending down of assets and, you know, selling a home and kind of all of those things with a view to Medi-Cal planning. Is it best for families to consult with an elder law attorney and or an estate planning attorney prior to doing this, or can they do it?
Absolutely.
Yeah.
Absolutely. So in California, I think one takeaway is you don't have to do a lot of pre-planning because we have all these alternatives. You have to have documents that allow you to do planning if your spouse or you lose capacity, but you don't actually have to give away assets or create irrevocable trust until somebody absolutely needs skilled nursing care.
Okay. Yeah. You know, once in a while, I'll just say, not in this particular webinar, but we do sometimes in other areas and also on the phones get questions about, there's still some misperceptions of some people that they need to be divorced and so forth in order to best qualify. So you're just saying the best bet is to get with an elder law attorney and an estate planning attorney to look at your specific situation and get good advice.
So I'm saying an elder law attorney, because I see too many people that go to their estate planning attorney and their estate planning attorney has a different set of blinders on. Okay. And they don't necessarily update their documents in a way that will allow this planning to happen in the future. And the other thing, as to married versus single, married couples have many more alternatives available under Medi-Cal than a single person. So it's
Got it.
better to be married.
Yeah, thank you, Andrea. And I'll just say to everyone here that, we have further information on elder law attorneys that we can give to families. I'm going to put the link to our follow-up form. And if you're interested in that, complete the form and we'll get you that information. I think we'll continue on here now, Andrea.
I'm sorry, I took a little too long, but we're getting really at the tail end, and the important thing is gather up your important documents, keep your documents in a location that is safe, but not necessarily a safe deposit box. And I think we can go to the next slide. Because a safe deposit box is typically closed in a night or weekend when somebody needs documents. Let your agent know where they can access the documents or how they can access online passwords or asset information. Update documents so that the provisions allow for government benefit plannings. Maybe you'll never need this skilled nursing, but your documents should at least provide flexibility. Find out what your specific institution needs to have on file. For example, does the durable power of attorney that your attorney drafts, will that be accepted by Vanguard or Fidelity, or do they have another form that they want signed? Same thing with the healthcare provider. The HIPAA waiver may work any place, but Scripps or Kaiser may have a form that they like better. So it's important to have all those loopholes closed, because when a crisis happens, you don't want to be in an argument with a provider as to what document they need. Discuss the contents of your advanced healthcare directive with your agents. Communicate your wishes to your attorney and doctor so they can help your documents have provisions that reflect your wishes. It's important to understand that we as attorneys don't know what your wishes are. So we need you to communicate that to us so we can guide you as to the potential alternatives you can have in your documents. You shouldn't assume that we know your wishes any more than your agent knows your wishes. Then looking at the next slide, everything we talked about today applies in California. Every state has its own rules. No other state is as generous as California when it comes to paying for long-term care. You need to seek counsel in that state where the parties reside. And the other thing you need to do is let your California lawyer know you intend to move or you're thinking about moving. Because if they do Medi-Cal planning for you in California and advise you to transfer your house or to make gifts, and then you move to another state that doesn't view that transaction in the same way, you may have a 60-month waiting period before you be eligible for Medi-Cal, even though you were eligible for it and receiving it in California at the time prior to the move. So then looking at the advanced planning resources. Okay, so the first one is the healthcare directive. You can download a statutory healthcare directive. It may not have all the bells and whistles that an attorney prepared form will have. I mean, I will tell you it won't have, but it will work to allow somebody to make healthcare decisions. So that's a starting point. There is also a physician's order for life-sustaining treatment that you can at least see what the form looks like, so that when you talk to your doctor, you understand what the choices are that you will be making as to the level of treatment. I highly recommend this Consumer's Toolkit for Healthcare Advanced Planning. I give it to my clients and I say to them, you know, I don't need the information to complete the healthcare directive, but it's a gift to your agent because you are setting forth what your wishes are so your agent knows how to make decisions. The last thing on this slide is dementia provisions that can be included in advanced healthcare directives so that your agent knows the level of care you want if you are suffering from dementia. So let's go to the next. These are all the places to find lawyers. The National Academy of Elder Law Attorneys. You can go on that website as well as the Alzheimer's site, and all the attorneys that Alzheimer's recommends are elder law attorneys. And then NALA is a national organization of elder law attorneys. So if you were going to be going to another state, you could find an attorney in that state. National Elder Law Foundation is another group of elder law attorneys. The State Bar of California is we're all licensed through the State Bar. You can look up any attorney and see if their license is current and they have been disciplined. The San Diego Bar Association is a local group of San Diego lawyers, and there is a trust and estates and probate section and elder law section. California Advocates for Nursing Home Reform is an excellent resource on all things that relate to Medi-Cal in California. So if you Google Medi-Cal, you'll often get the rules that are applicable in other states. So going to the Canner site, you will find the rules that are applicable just to California. Okay, the next slide. So these are the California government sites to various home care or residential care, skilled care licensees. So they all must be licensed. You can search a company's name that you're thinking of doing business with, or a facility's name, or a skilled nursing facility's name, and you can see how, if there's been any complaints, how the complaints were resolved. And the last one is the continuing care retirement community. Same thing, you can research those continuing care retirement communities, which are communities, again, that people buy into for a large amount, and then in return, they provide care through the balance of their life. So the next slide, benefits program. So a really important place to get information on Medicare is the Center for Medicare Advocacy. There are a number of consumer-friendly toolkits to help you navigate when your family member is in the hospital and they say they're being discharged because Medicare won't cover them any longer, and you don't believe they should be discharged. And it gives you the criteria for talking and appealing these decisions, because ultimately any discharge, whether it's from a hospital or a skilled nursing facility, must be safe. And if it's not safe for the person to return home, then it's not a safe discharge. Social Security website is improved a lot, but typically your I don't think you need to be on it too much other to find out maybe income information. The VA Caregiver Support Program is a lot of important information on the VA site that's available now for people, for veterans and caregivers. Let's see the next one. Oh, that's me. So these are the areas that I practice in: estate planning, elder law, special needs, Medi-Cal planning, veterans benefits. And it's been my pleasure to be speaking today to you.
Thank you so much for all. This is so much information to condense and to make sense of, and you did a great job of it. It's that's no small feat, everyone. So our thanks to you for handling as many of the questions in there as you could there, Jean. You were doing a great job. I know that there's some unanswered questions. We're running over. We're going to wrap up here. But please know that we are available for the answering of one-on-one questions, connecting you to resources, including Ms. Gherini and other local attorneys as needed. So I'll be brief about this, but Alzheimer's San Diego is, of course, a local nonprofit organization. Our mission is helping people who are affected by dementia and fighting stigma and supporting research. And we do all of these things through free programming, expert support, dementia expert consultation, support groups, education programs like this one, and on a lot of other topics, as well as respite and opportunities for socialization as well. So please let us know. Jean, if I could ask, could you put the link out in the chat one last time? If you are in need of any support or information, please do reach out. Let our team know how we can help. There's lots of great information on our website. You can call us. You can email us. You can even live chat us. There's a little box that pops up on the homepage of our website when you visit. But of course, that follow-up form is a very easy way to request some information. As it happens, we have a couple of webinars coming up on topics that are very closely related to some of the subjects that were covered in today's program. Next week, Jean will be doing a program on living at home resources for care options at home. So in-home care, adult day programs, PACE, some of those resources that were covered today. And then the following week, there'll be a program on residential placement. So making decisions about placement options, board and care, assisted living, memory care, skilled nursing facilities, how it all works, and the supplemental resources that can support you in making that decision and making it a smooth transition. So all that information, of course, is up on our website. When this webinar ends, you are going to get directed to a short survey. We would love your feedback on the program, anything else that you need. And as we've reminded you, I just want to reassure everyone, we are going to be sending out a copy of the slides. I know it was lots of information and lots of good links going out in the chat and in the Q&A. We'll send those to you as well as a recording of the webinar. We won't send that to you, but it will be available in our webinar library within a couple of days. It takes a little time for the recording to process and get in there. So with that, I want to be mindful of time, everyone's time, including yours. Andrea, thank you so much for sharing your expertise with all of us.
Thank you. Bye-bye.
Bye.